This video, prepared for the World Affairs Council of Austin, focuses on two key points of error regarding the legal status and actions against Artsakh. We are examining the background information that supports the case. Artsakh meets the Montevideo criteria, which legally defines statehood. It maintained a permanent population, a defined territory, a functioning government with executive, legislative, and judicial institutions, and was engaged in foreign relations. The first ICJ precedent supporting this is the 2010 Kosovo Advisory Opinion. This opinion holds that a declaration of independence is not prohibited by international law. Artsakh's claim to self-determination mirrors this precedent and legitimizes its self-government institutions. Case 2. The Western Sahara Advisory Opinion from 1975 emphasizes the primacy of self-determination over territorial claims. The court rejected the idea that competing claims can override a people's right to choose independence, strengthening Artsakh's sovereignty claim. The East Timor case from 1995 established that self-determination is an erga omnes obligation, a legal right enforceable against all states. This underscores that Azerbaijan cannot extinguish Artsakh's institutions through force. These precedents matter because they establish that statehood does not require UN recognition and that territorial disputes do not negate self-determination rights. Legally, the prosecution of Artsakh's leaders is the illegal dismantling of a sovereign entity, violating the UN Charter. Our second point of error concerns the 1948 Genocide Convention. Previous cases, like Bosnia versus Serbia, established that conditions of life include the deprivation of necessities. This is relevant to the 2023 acts, which constitute the deliberate infliction of conditions calculated to bring about physical destruction. The core legal question is whether the September 2023 events meet Article 2C of the Genocide Convention. Article 2C focuses on the deliberate infliction of conditions of life calculated to bring about physical destruction. In the Bosnia versus Serbia case, the ICJ held that genocide can be proven through patterns of conduct and conditions of life. The Latin blockade and subsequent forced displacement of Armenians mirror the ICJ's conditions of life standard. The Croatia versus Serbia case reaffirmed that genocide includes acts designed to destroy a group's ability to exist. The destruction of cultural sites and systematic patterns of deprivation provide evidence of intent. Finally, the Gambia versus Myanmar case established that forced displacement and denial of necessities are plausible genocide claims. The Artsakh case parallels this, with a blockade, starvation, and forced exodus meeting the plausibility of intent threshold. These cases establish a legal pattern that includes starvation, forced displacement, and infrastructure attacks as evidence of genocidal intent. The conclusion is that the September 2023 events in Artsakh meet the plausibility threshold for genocide. This preliminary hearing seeks to change the attitude towards justice by bringing the accused to justice, based on the established legal precedents and evidence of genocide.